Hello, class, and welcome to This Week in Ethics for Professionals of Alcohol and Drug Professionals. So, today, what we're going to be doing is kind of bringing everything together that we've been learning so far and go through a few ethical vignettes and help you to make some ethical decisions based upon what you have learned so far in this class. Now, just a few caveats. What we're going to be doing in this lecture is I will be presenting a scenario, and then I'll give you some time to kind of think about the scenario, and then I will give you what the professional associations say. Now, have to pick and choose what kind of professional association to help represent professionals. And so what I've gone with is the American Association of Marriage and Family Therapists. Now, while not strictly devoted to alcohol and drug professionals, it does serve a wide variety of counseling fields and is dealing with the whole scope of the individual and the family. And so that's part of the reason why I chose it, is it provides some unique perspectives that perhaps we wouldn't get when we're just working with individuals. So that's part of the reason why I chose it. And it is a good representation of professional associations in general. So let's kind of start off and get yourself comfortable, focus clearly on the task, and try to make decisions as best you can, and I will help you through that. Let's go. Very first one. Do both parents need to sign a disclosure statement providing consent to treat a child? Well, that can be a complicated one, isn't it? So, what are your thoughts on that? Well, the reality is, whether parents are living together or are divorced, generally Code of Ethics nor most regions require that both parents provide consent for treatment. So if parents are divorced, the parent who has been allocated the sole decision-making authority to select care providers is the only person with authority to authorize treatment. Now, if the divorce decree does not allocate to one parent or the other the authority to select care providers, then the primary custodian of the child is the parent with authority to consent to treatment. Now, the exception to this for most regions is that in the case of emergency, either parent may consent to treatment needed for a child. But best practice, generally speaking, is to have both parents sign your disclosure statement authorizing treatment. But just kind of be mindful. If you do so, keep in mind that both parents will need to sign the authorization for disclosure or release of information to third parties. And so this can become an administrative nightmare. So something to kind of be mindful of. Next one. I am teaching a parenting class and members of the class want to see me for treatment. Can I provide counseling to my students? Well, what do you think about that one? Well, generally, the answer is no, because of dual relationships. So, therapists do not provide therapy to current students or supervisees. Now, after the class has concluded, however, former students can seek treatment from you if they so desire. And there is no minimum time limit on this. Next question. When I am providing treatment to a minor and a parent asks for information concerning my client's problems or requests treatment records, what information and how much information should I disclose? This is a tough one. Whole idea of informed consent and confidentiality. What do you think? Well, the reality is most regions state that a therapist providing mental health services to a minor may, with or without consent of the minor, advise the parent or legal guardian of the minor of services being given. So in other words, you can tell the parent what kinds of services you're offering without giving detailed information. So if the adolescent client needs a referral for other services which you do not or cannot provide, then you may provide information concerning the referral to both the adolescent and the parents so that the parent may be involved in the referral process. Now, it gets a little more complicated than that. So when you first see a minor who has been brought in by a parent for counseling, let both of them know that you will need some degree of confidentiality with the adolescent so that you can discuss basic issues and problems such as drug or alcohol use, sexual experiences, or parent-child issues in confidence with the minor. And at the same time, let both the adolescent and the parent know that you will, in the exercise of your professional judgment, advise the parent of any services given or needed. And you might state this policy in your disclosure statement and have parent and minor sign both of it. And both clients then agree to this process, which will create a more safe atmosphere for the minor to disclose to you problems and feelings that will not necessarily be shared with the parent. And so establishing ground rules in this manner will help you later if the parent becomes too intrusive in asking questions and in questioning you about information disclosed by the adolescent. But I will unfortunately have to say that in most states, if push comes to shove and the parents take you to court, the court will probably release records to the parents as well. So just be mindful of that. Next question. If a client refuses to sign my disclosure statement, that is my informed consent statement and consent to treatment, can I then provide services to that individual? Well, what do you think? Well, if you recall, one of the most basic rules and rights of patients is the right to refuse treatment. So when a client refuses to sign your disclosure statement, which is your consent to treatment form, the client is not providing you with any consent to treatment and is thereby refusing treatment. So if a court has entered a short-term certification, for example, either the inpatient or for outpatient treatment, the court's order presumes that the individual concerned has refused voluntary treatment. And in this situation, you may offer your services, but the client is still entitled to refuse them. And the one time when this is not applicable is when the client is in danger to himself or another. And so in such cases, they can be held at a mental health facility for assessment. And they'll be assessed for any further risk that they may have. So at that point, generally, it'll be out of your hands. Okay, next question. I know that as a therapist, I am a mandatory reporter of child abuse and neglect. But when am I required to report? Well, give some thought to that. When are you required to report? Well, whenever a therapist has a reasonable cause to know or suspect a child has been subjected to abuse and neglect, the therapist shall immediately make a report to social services or local law enforcement. And this generally includes whenever a therapist has observed the child being subjected to circumstances or conditions which would reasonably result in neglect or abuse. And so information which you are required to report is as follows: name, address, age, sex, and race of the child, name and address of the person responsible for the suspected abuse and neglect, the nature and extent of the child's injuries, whatever information you can give them as far as family composition, your name, address, occupation as the person who is reporting, and any action taken by the reporting source. So, like, for example, referral to a safe house or something like that. And any other information that you believe may have been helpful in protecting the client or in conducting the investigation. Having made the report of suspected abuse or neglect, a therapist is entitled to immunity in some jurisdictions. So, like, for example, in Colorado, a person cannot be sued for reporting on possible child abuse. So that's something to be mindful of as well. So, next question. What normally constitutes child abuse or neglect? Well, give some thought to that. Child abuse typically means an act or omission that threatens the health or welfare of a child. And this includes injury to the child evidenced by skin bruising, bleeding, malnutrition, failure to thrive, so overall ill health, burns. Other things include subjecting a child to sexual assault or molestation, sexual exploitation, or prostitution, or anything that may be subjecting the child to emotional abuse when an identifiable and substantial impairment of the child's intellectual and psychological functioning occurs. And then finally, neglect would occur when a child's parents or custodian fails to provide adequate food, clothing, shelter, medical care, or supervision that a prudent parent would provide. And so neglect also includes a situation where a parent or legal custodian has allowed another person to mistreat or abuse a child without taking lawful steps to stop such mistreatment or abuse and to prevent it from recurring. Next question. When do I have the duty to warn of a threat? When my client, or a duty to protect against violence which may be committed by a client? Well, in this case, all mental health professionals have a duty to warn and protect whenever a client has communicated a serious threat of imminent physical violence against a specific person or persons. Now, most jurisdictions normally require a therapist to warn of such a threat by making what was called reasonable and timely efforts to notify any person or persons specifically threatened, as well as by notifying an appropriate law enforcement agency, and by taking other appropriate action, including hospitalizing the client. And a therapist who has complied with this duty to warn and protect is then entitled to immunity in most states. Immunity from any civil liability or professional discipline for making such a warning. So there's a caveat in most legislations and in most professional associations when you're breaking confidentiality for mandatory reporting. So, as a mental health professional, can I initiate a 72-hour hold on a client? Well, you may initiate a hold. Typically what you will do is simply take someone to a licensed mental health professional, and that licensed mental health professional will sign an M1 form which authorizes a person to be taken into custody for up to 72 hours for an emergency mental health evaluation to be conducted in a hospital setting or at the crisis unit of a community mental health center. So that's something to kind of be mindful of, is basically just take them to the hospital and they'll be taken care of there. I have a client who is currently having problems related to sexual abuse from 20 years ago. The abuse was never reported. Do I have a duty to report in this case? Well, in this case, the answer is no. Most jurisdictions mandate reporting when a child has been subjected to abuse and neglect, but no professional boards offer any guidance really on reporting when the victim is now an adult. It's kind of, at that point, it is an issue for the adult themselves to report if they want to. And that is an added factor which could affect whether a therapist has a duty to report the past child abuse without the client's consent. And so one way to deal with this is to send a letter. If you have any questions, send a letter to the licensing board, kind of outline things and ask them about it. But it's really up to the adult at that time. And so the requirement for you is to keep confidentiality. Now, how long should I keep client records? And what kinds of records should I keep? Well, most states prohibit the failure to make essential entries on patient records and require keeping them for 7 years after termination of treatment. And the rule also usually specifies which records must be kept and what record-keeping entries must be made. Basic things like who the person was, who the therapist was, the client's address and age, the reasons for the therapy, the type of therapy provided, the dates of contact with the primary client, any adequate and reasonable case management records, and the name of any tests administered, the dates that those are administered, and who administered those tests. Another question about record keeping. When a client demands a copy of my file, must I copy it for them? This one is tricky, and so I'll just kind of talk about it a little bit. Generally speaking, the client has access to their own records. What you choose to show them is up to you, but if they were to take you to court, you would likely have to show them all records. So be mindful what you put in the records. I have been subpoenaed to testify about former clients who are a couple, who I saw for couples counseling. The subpoena also requires that a copy of my records concerning the couple's counseling be brought to court. And the wife has consented to my testimony and to release the records to her attorney. But the husband has refused to consent to my disclosing any information concerning the couple's counseling. What should I do? Well, in this case, since both parties are clients, and since they both did not consent, you cannot release that. So ideally what you will do is bring the information to court but explain to the judge that you have an ethical obligation to keep confidentiality because someone did not file for release. And so the best practice generally is that you would file what's called a motion for protective order with a hired lawyer. And this raises the whole issue of confidentiality and the professional association ethical principles involved. And so the court can make a ruling regarding that at that time. Typically, a court will not force you to do it unless, especially if it's just a civil case. Another question. I have seen a mom and her children in counseling to deal with issues concerning parent-adolescent problems and divorce issues. Mom and dad are separated. Mom's attorney wants me to testify that mom should have all parenting rights and responsibilities. I have never met the husband and know little about him except for information provided by mom concerning his drug use and his acts of domestic violence. Can I testify as an expert witness for mom in the divorce case? Want you to think on this one. This is a tricky one. And the answer is no, you can't. You should not do so for several reasons. First off, mental health professionals may make specific recommendations regarding custody when the professional has interviewed and assessed all parties to the dispute. And here you would be assessing the quality of the relationship or the potential for establishing a quality relationship between the child and each of the parties, and had access to pertinent outside sources. But not having conducted the necessary assessment of the parties and their relationship involved means that you shouldn't testify. And so this also involves, of course, the conflict of interest. Marriage and family therapists who treat minors and adults involved in custody or visitation actions shouldn't be performing those evaluations, because that makes kind of a dual relationship that we do not want to have. So generally speaking, if you did something like this, where you were testifying on behalf of a client, you would and basically testifying against somebody else that you did not have any interaction with, you would probably be sued for basically a drive-by sabotage of their character. Am I allowed to trade services with a client or engage in bartering? This is one, you want to get paid, but maybe necessarily they don't have cash. Maybe they have a catering business, or they have a tire company or something, and they want to, change out the tires in your car. Now, normally, therapists refrain from accepting goods and services from clients in return for services, but you can do it if there is a certain situation. So if the supervisor or client requests it and you don't request it, that may be, as long as the relationship also is clearly not exploitive and that the professional relationship is not distorted in any way, and there's a clear written contract to establish this. As long as those things are set in place, then you should be okay in doing this sort of thing. If a client fails to pay for professional services, can I turn the account over to a collection agency or sue in order to collect debt? Oh, this is a tough one. Can you do that? Oh. Only way you can do it basically is if you have a form that's been filled out by the client already that says that if they don't pay, then you can send it to collection agency, and they've agreed to it. If that has not been in place, and if you have not given them notice of this, then you cannot reveal that anything in the relationship has taken place. And so you would have, and this is the practical matter is that it is impossible to prove your case in court without disclosing clinical information, which violates confidentiality rules, which puts your whole right to practice in jeopardy. So it's really not worth it unless you have crossed your T's and dotted your I's with forms prior to the establishment of the counseling sessions. So I hope you found that fascinating and interesting, and thank you very much for participating in that case vignette. Hope you have a wonderful week. You take care. Goodbye.